Hello candidates, I am going to dictate you a passage from Legal Progressive magazine. So please get ready for the dictation. The dictation will start after 15 seconds. The scheme under Section 391 of the Companies Act has been very elaborately dealt with by this court in the case of M.H. Mafatlal versus Mafatlal Industries Limited, reported in AIR 1997 SC 506. From a perusal of the various principles laid down in Mafatlal case, it is clear that the proposed scheme cannot be violative of any provision of law, nor can it be contrary to public policy here. In Hindustan Lever and another versus State of Maharashtra and another, it has been reiterated that a scheme under Section 391 of the Companies Act is binding on all shareholders, including those who oppose it from being sanctioned. It has also been reiterated that the jurisdiction of the Company Court while sanctioning the scheme is supervisory. This court in Hindustan Lever case also care accepted the principle laid down in para 29 in Mafatlal discussed above and held that a scheme under section 391 of the Companies Act cannot be unfair or contrary to public policy, nor can it be unconscionable or against the law in the case of administrator of the specified undertaking of the Unit Trust of India and another versus Garware Polyester Limited. This court held that a scheme under section 391 of the Companies Act is a commercial document and the principles laid down in the case of Mafatlal have been relied upon, and it has been reiterated that the scheme must be fair, just and reasonable and should not contravene public policy or any statutory provision, and has been expressly quoted and approved. Therefore, the main argument of the learned counsel for the appellants that once a scheme under section 391 of the Companies Act is sanctioned by the court, the same operates as compounding of offence under section 138 read with section 141 of the NI Act cannot be accepted. Rather, the principle which has been reiterated by this court repeatedly in the aforesaid judgments is that a scheme under section 391 of the Companies Act cannot be contrary to any law. From this consistent view of this court, it clearly follows that a scheme under section 391 of the Companies Act cannot have the effect of overriding the requirement of any law prevailing in the country now.